Madam Secretary, on April 24th, a woman in Louisiana was deported along with her 7-year-old daughter and 4-year-old son, both of whom were U.S. citizens. The 4-year-old son had stage 4 cancer. Now, you just stated under oath that the mother consented to having her U.S. citizen children removed. But I have spoken with the attorney for that U.S. citizen child with stage 4 cancer. She has also made numerous statements to the press in which she stated unequivocally that at no time did the mother consent to her U.S. citizen children being removed. What evidence do you have to support your claim that she did consent?
Congressman, we followed the same policies and procedures.
What evidence do you have? What evidence do you have that she? What documentation do you have that mother consented?
We will get that to you, sir. I don't have it with me.
Please do. I understand it's hard to keep them all straight because you've deported multiple U.S. citizen children, but I'm asking specifically.
This is one of those moments where the room goes quiet because the facts speak for themselves. A 4-year-old American citizen with stage 4 cancer was deported, and today lawmakers are demanding to know how that happened, who approved it, and whether the law was ignored. Watch closely. Accountability starts here.
Specifically about the 4-year-old with cancer who was deported on April 25th. For the record, that family was also not given access to legal counsel before they were deported, even though their lawyer was in the same building at the time. I'm holding in my hands here a document called ICE Directive 11064, Interests of Non-Citizen Parents and Legal Guardians of Minor Children. This is the policy for how ICE agents should handle situations like this. It states unequivocally that parents and legal guardians should have the ability to make alternative care arrangements for minor children prior to their arrest or detention, and that ICE must afford parents the opportunity to consult with legal counsel. So, did the ICE agents working on this case who deported this 4-year-old with cancer of their own volition fail to follow ICE policies, or were they directed to by your office or anyone else in DHS leadership?
Sir, this mother chose to keep her child with her.
You have not produced any evidence to say so, but I'm asking again, have you directed DHS officers to ignore this
It's
policy?
very different than the previous administration. The previous administration
on March 15th, reclaiming my time, on March 15th, your department sent 3 airplanes to El Salvador. Those planes carried approximately 261 individuals who were imprisoned upon arrival. Did you personally review and approve the names of those 261 individuals before they were sent?
Sir, we have deported and sent home
did you review the names of those individuals?
And we have individuals that have
why won't you answer the question?
Within the Department of
Are you
Homeland
aware
Security.
of whether those 261 individuals were given the opportunity to speak with a lawyer or appear before a judge before they were put on those planes? Yes or no?
Sir, every single individual followed the exact same process.
They were not all given the opportunity to appear before a judge or speak with a lawyer. On April 7th, the Supreme Court ruled that detainees must have an opportunity to have a hearing before they are deported. Are you familiar with the April 7th Supreme Court ruling?
I am.
Can you assure us that in the future you will abide by that Supreme Court ruling to provide detainees with a hearing before they are deported?
We're following all judges' orders. Yes, sir.
I have a photograph here of André Hernandez Romero, a gay makeup artist from Venezuela. He fled Venezuela fearing gang violence because of his opposition to the Maduro dictatorship and his sexual orientation. He presented himself at a port of entry and requested asylum. His claim was found to be credible, and he was placed in detention to await a full hearing. But he never received a full hearing because you put him on one of those planes to El Salvador, where he still is today. Listen to me. He had no criminal record in the United States or in any other country. He did not even enter the country illegally. He presented at a port of entry. He tried to do it the legal way, and to this date, the only evidence your department has presented to justify his imprisonment is that he had 2 tattoos, one that said mom and one that said dad. Do you have any other evidence to present for why this individual should be locked up in El Salvador?
Sir, every case is used the same protocols and the same processes and inputs.
Do you have any evidence other than the tattoos that say mom or dad for why this individual
should be locked up?
It's not just on
tattoos. It's who they're affiliated with, their communication.
You have not presented any other evidence, nor has your department. Reclaiming my time, during your confirmation hearing, you said your focus would be on deporting immigrants who have been convicted of crimes and those who have received removal orders. But that is not what you have been doing. Instead, you have been deporting children with cancer, children who are U.S. citizens, a gay makeup artist who committed no crime and didn't even enter the country illegally. You have been sloppy. Your department has been sloppy, and instead of focusing on real criminals, you have allowed innocent children to be deported while you fly around the country playing dress up for the cameras. Instead of enforcing the laws, you have repeatedly broken them. You need to change course immediately before more innocent people are hurt on your watch.
Gentleman's time has expired. I now recognize...
What makes this exchange so consequential is not just the heartbreaking facts, but what it reveals about how power is being exercised when the people affected are least able to protect themselves. A 4-year-old American citizen with stage 4 cancer is not an abstraction. This is a child whose life depends on continuity of medical care, whose legal status is unambiguous, and whose constitutional protections should be absolute. When Representative Seth Magaziner presses Secretary Noem, he isn't arguing policy philosophy. He is testing whether the government followed its own written rules, court decisions, and sworn obligations. At the center of the administration's defense is a single claim, that the mother consented to having her U.S. citizen children removed from the country. That word carries enormous legal weight. Consent determines whether an action was lawful or coercive. But when Magaziner asks the most basic follow-up, what document proves that consent, there is no answer. No form, no signature, no contemporaneous record, just a promise to provide evidence later. That gap matters because ICE policy is not vague. Directive 11064 explicitly states that parents must be given the opportunity to consult legal counsel and arrange alternative care for minor children before deportation. According to the record presented here, the family's attorney was physically present in the same building, yet the children were deported anyway. If that is accurate, the issue isn't judgment, it's compliance. Magaziner then broadens the lens, and this is where viewers should pay close attention. He ties this case to a pattern: flights carrying hundreds of detainees to El Salvador, uncertainty about access to lawyers, and deportations that appear to have occurred before individuals received hearings, even after the Supreme Court ruled that detainees must have that opportunity. When asked whether leadership personally reviewed those cases, the answers remain non-specific. Responsibility becomes diffuse. Accountability drifts. The asylum case he raises underscores why due process exists in the first place. An individual who entered legally, passed a credible fear screening, had no criminal record, and awaited a hearing, was deported anyway. The only evidence cited publicly involved tattoos that, on their face, have no inherent criminal meaning. When Magaziner asks whether there is any additional evidence, none is articulated. That silence is not proof of wrongdoing by the detainee, it is a warning sign about the standards being used. This is how systems fail people without announcing it, not with one dramatic order, but through shortcuts, assumptions, and an erosion of safeguards that are supposed to prevent irreversible harm. Children don't get deported because of ideology. They get deported when procedures break down, and no one stops the machinery in time. What this hearing teaches viewers is that immigration enforcement is not just about borders, it is about process. The Constitution does not say due process for some. It does not say hearings unless inconvenient. It exists precisely for moments like this, when the government's power is at its greatest and an individual's voice is at its weakest. Oversight hearings are not theater when they force these facts onto the public record. Once that record exists, it cannot be undone. The question that remains is whether it will lead to course correction or whether these cases will be treated as acceptable collateral. If this breakdown helped you understand why process matters as much as policy, stay engaged, like the video, subscribe.